I think Facebook might even be working, so let's start. Not yet.
Dear colleagues, dear students, ladies and gentlemen, it is a great pleasure to open this evening's guest lecture on the topic Invisible Refugees, Persons with Disabilities and Their Right to Refugee Status. The lecture will be given by Dr. Stephanie Motz, who I will introduce to you shortly. I wish you a very warm welcome, and I'm happy that you are here with us tonight, not only for the guest lecture, but also to mark with us the 70th anniversary of the Geneva Refugee Convention. I am welcoming you tonight with a double hat. First of all, in my capacity of Vice Dean of the Geneva Law Faculty, who has provided financial support to this event. Our faculty has many ties with international organizations, with the Genève Internationale, as we call it. We very much value the numerous forms of collaborations and interactions with international bodies, and we are delighted that the collaboration with the UNHCR has led to the lecture of this evening. Geneva is the natural place to commemorate the 70th anniversary of the 1951 Refugee Convention, also known, as you all know, as the Geneva Convention. I mentioned before that I am welcoming you with a double hat, so it's time to put on my other hat. A warm welcome also in the name of the Law Clinic of the Rights of Vulnerable Persons, which I have the privilege to run together with a team of highly motivated and highly dedicated scholars. Let me mention them: Dr. Neza Zimmerman, who you have already met on screen, Ms. Vista Eskandari and Mr. Quentin Markarian. Neza has played a pivotal role in organizing tonight's conference, and I would like to address a special thank you to her. Neza will be taking over later again and moderate the questions and answer session after the guest lecture. Quentin will also help us with the moderation, taking over the moderation of the Facebook live chat, which, as I understood, now works, so that's great news. And so many thanks to Quentin too. Let me say a few words about the Law Clinic and the link between our clinical work and the event of this evening. Clinical teaching originated on the North American continent. Law clinics have mainly two characteristics. Firstly, they are a method of teaching which makes students engage in practical work. And secondly, they have a pro bono component. Clinical work can take many forms. For example, offer legal advice in individual cases or even take individual cases to court. Writing briefs for international bodies or NGOs. Take a more general approach and disseminate legal information to those who need it. Our law clinic has so far adopted the third, more general approach, also known as Know Your Rights law clinics. Nul n'est censé ignorer la loi. Nobody is supposed to ignore the law. This is a basic principle we teach our law students. We all know that it is a presumption, if not to say in many cases a fiction. This is all the more the case for people in situations of vulnerability. The Law Clinic seeks to clarify through research the legal situation and to make information available through texts which are easily accessible and easily understandable. Knowing one's rights is a form of empowerment, as rights can't be exercised if they are not known. The research we carry out makes us not only focus on rights, it also makes us aware of the absence of rights or of practical impediments to vindicate them. The Law Clinic thus also has a critical dimension. It encourages us and the students to reflect critically on the law and can also fuel further research. Our clinical work entails close collaborations with representatives and members of the groups we are focusing on. They know best what legal issues need clarifying and are of practical relevance for them. We also work closely with civil society, international bodies, and the local authorities. So far, we have always worked on topics which are directly relevant for Geneva. Our work has been synthesized in publications which are available on our website. So far, we have been working on the rights of Roma in precarious situation, a topic which you may have seen in the media after the European Court of Human Rights held that a complete ban of begging, which is enforced in Geneva or was enforced in Geneva, breaches the European Convention. We have also worked on the rights of women without residence status, on the rights of people in pretrial detention in the Geneva prison of Champnelon, the rights of the LGBTIQ community, the rights of unaccompanied minors and young people. And lastly, since the beginning of the academic year, we have been working on the rights of people with disabilities, a topic we will continue working on the next year too. In many of the topics I have mentioned, migration law in general and refugee law have played a considerable role. Topics like refugee status of LGBTIQ persons and unaccompanied children easily spring to mind, and it comes as no surprise that the UNHCR has worked on all of them. I must admit that the topic we are focusing on tonight, persons with disabilities and their rights to refugee status, was not the first topic which came to my mind. Maybe, as the title of tonight's lecture suggests, because this group is invisible. If it is invisible, it is all the more a reason to explore this issue, to cast light on it. And this is what Dr. Stephanie Motz will be doing in her lecture. In making these refugees with disabilities more visible, she will complement and enrich our clinical work, which focuses on the rights of people with disabilities more broadly. It is time to say a few words about our guest lecturer. Dr. Stephanie Motz studied law at King's College in London, and she completed and then got a master's degree at Oxford University. She lectured as a tutor in public law at King's College, and following her training as a barrister, she worked at a law firm in London. For several years, Dr. Motz has been practicing in Zurich in areas of asylum and immigration law. Practicing as a lawyer, Stephanie Motz regularly represents asylum applicants before international bodies, namely the UN Committee Against Torture and the European Court of Human Rights. She has also had the opportunity to gather practical experience via internships at the International Criminal Court and the Greek Council for Refugees. In addition to her legal practice, Dr. Motz pursues a career in academia, both in teaching and research. Her PhD was published with the prestigious editing house Brill last November. The title of her work is The Refugee Status of Persons with Disabilities. Stephanie Motz is thus particularly well suited to address the topic we are focusing on tonight. I am extremely grateful to her for taking the time to be with us and thank her very warmly in the name of the Law Clinic. Before passing her the floor, I am handing over to Anja Kluge, who will say a few words on behalf of the UNHCR. I wish you a very good evening and thank you for your attention.
Dear participants, a warm welcome also on behalf of UNHCR to this third lecture this year of our series in commemoration of the 70th anniversary of the 1951 Refugee Convention. It will focus, you have already heard it, on a topic which is very rarely discussed: the need of for the refugee protection of persons with disabilities. The image of a refugee many people continue to have is that of a political activist who has come under threat. The lecture today will bring to the fore that this is a far too limited understanding of the refugee definition. Persecution is not only driven by political activism. At its core is the decision to define certain individuals or groups as threat. simply for what they are and to exclude them from the community. This is the political act against which refugee status offers protection. I would like to thank Professor Maya Hertig-Randall from the University of Geneva, Dr. Zimmermann and Dr. Eskandari of the Law Clinic on the Rights of Vulnerable Persons for having chosen a topic for tonight's lecture, which will broaden and deepen our understanding of the refugee concept in general, and for having invited Dr. Stephanie Motz, a known expert on this topic, to guide us through this theme. I wish us all a very interesting lecture.
Thank you very much. And I'd first of all like to thank Professor Hertig-Randall and Anja Klug and Dr. Lisa Zimmermann for the invitation to speak tonight. It's a great honor and pleasure to be able to contribute to this lecture series celebrating the 70th anniversary of the Refugee Convention this year. I will now share my screen. Right. So yes, it's already been said. The topic of refugees with disabilities is my specialization, and it is a topic that's very dear to my heart. I have spent several years researching this question, and it struck me throughout my research, and I think it is apt to remember this today on the occasion of the 70th anniversary of the Refugee Convention, that persons with disabilities have been persecuted for a very long time, and indeed they were one of the main groups who were persecuted during the Third Reich prior to the drafting of the Refugee Convention. And even though they were a large group of persecuted persons during that era, they did not make it into the Refugee Convention. They did not get any explicit mention in the convention. And I have hesitated a guess in my book on this, that it may well be that at the time the Refugee Convention was drafted, many states did not have incredibly favorable laws in relation to persons with disabilities yet. And so perhaps that may have been a reason why the topic was just avoided at that point. But they weren't just persecuted during the sort of 30s and early 40s. Persons with disabilities are a group of persons who remain very persecuted in many parts of the world today. They face forced institutionalization, forced treatment. In many countries, they get chained to beds, get detained in caged beds. They get chained to trees. They are persecuted sometimes from the moment of their birth, because certain communities or regions view them as impersonating the devil because they have a disability. The list is endless. That is why it's all the more striking that up to this day, they have found very little recognition in domestic and international refugee law. And so what I want to look at today is the question when persons with disabilities actually qualify for refugee status. Let me just, sorry. Yes. So the structure of my presentation today will be as follows. I will first of all just briefly set out the situation of refugees with disabilities in general. And then in a second step, and that will be the main part of my presentation today, I will show how a disability-specific interpretation of the refugee definition under the 1951 Refugee Convention is possible. And at the very end, I will conclude by referring to some recent developments at the international level, which actually give us hope that the issue of refugees with disabilities will not be ignored for much longer. So, starting with the situation of refugees with disabilities, first of all, I just want to clarify a few basics so that we're all on the same page. Now, what is a disability? So who are we talking about? And I've set out here the definition in Article 1 of the Convention on the Rights of Persons with Disabilities, which states persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. Now, there are a few things I'd like to say about this. First of all, even though I like to refer to it as a definition, it in fact isn't a definition. It's deliberately framed as the purpose of the Convention on the Rights of Persons with Disabilities, but it's not entitled a definition. And that was done so as to avoid legalistic interpretations of each individual element, so as to exclude certain people from the scope of the convention. So while it obviously serves as a benchmark, it's not meant to be dissected in minute detail in order to define whether someone is indeed a person with disabilities. The focus of this article is on actually three elements. First of all, it focuses on long-term impairments. And of course, we all know that's kind of the starting point of what we think of when we think of disability. It's someone's got some kind of physical impairment, mental, intellectual, or sensory impairment. But the importance here is that the focus of the Convention on the Rights of Persons with Disabilities is on the fact that not the impairment is the problem, but the way society hinders people with impairments to take part in society and in life in general. So actually it's the barriers which disable the person, not the impairment. So that's the second aspect of this article, is the interaction with various barriers. So we all know, lots of us will probably have a visual impairment. I wear contact lenses, many of us wear that, or glasses, but we don't experience barriers. We do have an impairment, but we are not disabled, because in fact we can fully enjoy life like everyone else who's not visually impaired. And the point is that a lot of our day-to-day life, our streets, our traffic system, our buildings, everything is geared towards the non-disabled mainstream population. And that's what creates barriers. So that's very much the focus of the entire Convention on the Rights of Persons with Disabilities, is the focus on the barriers that society creates for persons who have impairments. And the third element here in Article 1 is that it hinders the full and effective participation in society on an equal basis with others. So it's a very broad notion. Anything that somehow hinders your full and effective participation in society would therefore qualify. And I just want to compare this to the definition we have in Swiss law in the Disability Discrimination Act in Article 2, paragraph 1. It is a similar definition, but it is slightly different. It states that a person with a disability is a person who, due to a physical, mental, or psychological impairment, which is likely to be permanent, finds it difficult or is unable to carry out everyday tasks, cultivate social contacts, move around, obtain an education or training or work. And one of the main differences certainly is the emphasis on permanence here. We've seen with the CRPD, with the convention, it's a long-term, but it does not have to be permanent. That's one difference. And the other one is that it's very specific in terms of what it doesn't refer to barriers, and it's very specific in relation to what people are actually hindered from, so certain tasks. And I think the convention's definition is broader in the sense that it is just anything. If you are not able to participate in society, live on an equal basis with others, that is enough. So it's not as specifically targeted to individual points as is the Swiss definition. And Switzerland is, I think, up for review at the CRPD committee this year. So it will be interesting to see what comes out of this review. This was just to say who we are talking about when I speak of persons with disabilities. Now, the next question is, of course, are there that many refugees with disabilities? Now, in terms of the percentage of persons with disabilities amongst the general world population, it's about 15%. According to the Federal Office for Statistics, the Swiss Federal Office for Statistics, it's approximately 20% of the Swiss population who has a disability. And it is also estimated that about 20% of world's refugees and internally displaced persons have a disability. So there's actually quite a large percentage of people in the refugee law system, in the asylum system, who have disabilities. And that is not to say that, of course, in every case that will necessarily be relevant to the question of refugee status determination, but it is still a strikingly high number for the fact that, as I said at the outset, it's an invisible phenomenon at the moment in asylum law, mostly. And in fact, what I have found looking through case law for my PhD and for my book is that in many countries, in many asylum states around the world, persons with disabilities who face some form of ill treatment in their country of origin for reasons of their disability do not get refugee status. Very often they will receive some sort of humanitarian or compassionate status instead, if anything, if they don't get refused. And in Switzerland, in fact, my study, I also studied the Swiss system for another publication in relation to refugees with disabilities. They get a temporary admission, but not refugee status on the basis of disability. So it's been examined in a few cases, but not yet granted, the question of refugee status for persons with disabilities. So in most countries, it's still seen as a problem, a humanitarian problem, really. And that is very much the way of thinking that predates the UN Convention on the Rights of Persons with Disabilities. Persons with disabilities used to be thought of as a medical problem. They need treatment and then they're fine. And like I said before, what the convention really seeks to achieve is to show that it isn't the impairment that's the problem, but it is the way society deals with that. To this day, the human rights-based approach to disability that informs the Convention on the Rights of Persons with Disabilities throughout has not actually reached asylum law or international refugee law yet. There are some states which I found in my study that have more progressive case law on persons with disabilities, particularly Canada and New Zealand, sometimes Australia as well, and sometimes the United States. But it's still sort of in early days. But there are some good best practice examples, certainly from individual jurisdictions. Now, I want to turn to the question of a disability-specific refugee definition. Now, what do I mean by that? Of course, the refugee definition is what we all know, contained in Article 1A, paragraph 2 of the 1951 Refugee Convention. And it is the general standard formulation that a refugee is a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality and is unable, or owing to such fear, unwilling to avail himself of the protection of that country. So what is so special about persons with disabilities? Well, of course, if a state aims to exterminate all persons with disabilities in its territory, that will clearly mean that these persons qualify for refugee status. The problem is that the actual forms of persecution that persons with disabilities face are often more insidious and disability specific. And that is why it is important to look at a disability specific interpretation of the refugee definition. And when I say that, I of course I rely on a tradition in refugee law that, and Anja Klug referred to this, that initially when refugee law first started, what one thought of when one thought of a refugee was the political activist who is threatened because of his political opinion. The very sort of male archetype of the refugee. But of course, over the years, international refugee law came to realize that there are various forms of persecution, and that first of all, women are persecuted in ways differently from men. And that was the first step in recognizing in international refugee law that there are sort of group-specific ways in which the refugee definition needs to be interpreted. And UNHCR gave expression to that in its International Protection Guidelines #1 in 2002. And in fact, what this is a recognition that, for instance, with women, and this is relevant also for persons with disabilities, that actor of persecution often isn't the state, but private persons. So in many cases with persons with disabilities, the persecutory actor could be a family member or a religious institution, but not a state institution, or some other, just the general population, as I mentioned before. For instance, one example is Nigeria, where disabled children will often be considered to be witches, and therefore are persecuted by just the population in general, society, and not the state. So very often we have private actor persecution, and that is something that was already recognized in the early 2000s, late 90s actually, that private actor persecution is something that is covered by the refugee definition. Of course, there are other aspects which are relevant to the gender-specific refugee definition, various forms of domestic violence, which again is also highly relevant to the question of persons with disabilities, because as I indicated before, unfortunately, forms of harm also many forms of harm come from family members or carers. So that's one example. And then of course, as the years progressed and the United Nations Convention on the Rights of the Child gathered support internationally, international refugee law changed and adopted a child-specific refugee definition. And that is now also well recognized that there are certain specific forms of harm particular to children, and they may be child recruitment into military service, or other aspects, street begging, or child prostitution, of course, child porn, all these various horrible forms. But there is again a recognition now at the international level that there are child-specific forms of harm. And then I mentioned as the most recent sort of group-specific guidance, the LGBTIQ specific refugee definition, which again was also taken up by UNHCR in its international protection guidelines. And at the moment, I mean, disability is recognized in some of the UNHCR EXCOM conclusions as a topic of importance, and that needs to be taken into account. But there are at the moment no guidelines at the international level concerning refugees with disabilities and their right to refugee status. So we aren't there yet. And perhaps one of the reasons why we aren't there yet is that the CRPD is the most recent UN Human Rights Treaty. The CRPD was adopted in 2006 and entered into force in 2008. Switzerland, for Switzerland, it entered into force in May 2014. And what you see here is that actually the CRPD is very, very widely ratified treaty. So it has 182 ratifications and accessions, and the optional protocol for the individual communications procedures also ratified by 96 states, which is quite a lot. And here you see just the gray areas, other states that haven't signed the CRPD today. So it is a human rights treaty which has gathered very broad acceptance actually very quickly, yeah, can be considered to have almost universal acceptance now at the international level. So what does this mean for the refugee definition? There is such a thing as the human rights-based approach to the refugee definition. And what this says is that each of the elements of the refugee definition needs to be interpreted in a way that is compatible with international human rights guarantees, especially those which are sort of universally accepted, which this benchmark would be met by the CRPD according to academic literature. And so this means that I have now split the individual elements here from the refugee definition, that each of these, being outside the country of origin is perhaps the least important one, but each of the other elements needs to be interpreted in a manner that takes into account the human rights guarantees enshrined in the CRPD. And I will go into some of them in more detail in a moment. I just want to briefly say that so for instance, the for reasons of clause, which is in the middle here, which is effectively the causal link requirement within the refugee definition, namely that a person only qualifies for refugee status if the persecution they fear is for a reason of a personal attribute, such as race, religion, political opinion, nationality, or membership of a particular social group. And this causal link requirement is something that, for instance, in Swiss law is not explicitly discussed, and in fact it's relatively difficult to discern what the test is. I have sought to do that in a study. But in international refugee law, it is expressly considered normally in decision making. And here, the main question is, of course, that it has to be some sort of discriminatory situation. It has got to be, the persecutory situation has to be somehow discriminatory. And that can be directly discriminatory or indirectly discriminatory. So also here you have international human rights law in relation to the prohibition of discrimination, which is relevant. That is just a side remark, because I will not consider this in more detail, and the other element I don't consider in more detail is the well-foundedness of the fear. And just in relation to that, I would like to say that, of course, every refugee needs to have a well-founded fear of being persecuted. And well-founded fear, that formulation has both a subjective and an objective element. And fear is objectively well-founded if, on the basis of the information available in relation to that state, there is a real risk that the person would be persecuted upon return. But there is also the subjective element of the fear. And that is, of course, something that in relation to persons with disabilities is, depending on what type of disability it is, perhaps not as important. So if there is a person who's got a mental disability or possibly a psychosocial disability, it may well be that the emphasis has to be more on the objective situation rather than the subjective situation, which is something that is similar, for instance, in the refugee claims of children, and has already been developed in international refugee law when children, as far as children are concerned. But I'd like to look at three of the other elements now. First of all, just because this is sort of the most fundamental aspect, your sort of gateway into the Refugee Convention is you need a convention ground. If you are just fleeing war and there is absolutely no personal attribute that distinguishes you from everyone else in the country, you would not qualify as a refugee. So what is the distinguishing attribute for persons with disabilities? Of course, there may be other criteria such as religion or political opinion or race or whatever, or gender, etc., that come into play. But at the most basic level, persons with disabilities normally qualify as members of a particular social group. So that's one of the convention grounds listed in the Refugee Convention, of course. And what I found from my examination of the case law that, like I said, exists in certain countries on refugees with disabilities, is that normally claims did not fail on the basis of this requirement. And I mean, I've just put in the definition of membership of a particular social group here from UNHCR in its guidelines on international protection number 2 on exactly this point. And the definition is, and that's generally speaking accepted at the international level, that a particular social group is a group of persons who share a common characteristic other than the risk of being persecuted, or who are perceived as a group by society. And the characteristic will often be one which is innate, unchangeable, or otherwise fundamental to identity, conscience, or the exercise of one's human rights. And I mean, obviously, very often disability will be an unchangeable or innate characteristic of the person. So it actually meets this criterion. In certain countries, you need to demonstrate that the person is also perceived as a group by society, and then, of course, that will require some examination of that particular country of origin. Just to mention it here, I mean, in Switzerland, actually, we do not have an explicit test for this group. Our court still kind of keeps it a bit secret how they decide on who is a member of a particular social group, but generally speaking, where persons are, where there is a situation of persecution, normally for such persons, there would be a finding that they are also a member of a particular social group. And from my examination of the case law of the Federal Administrative Court, it's been the case that basically Federal Administrative Court accepts that persons with disabilities can form a particular social group. And just to say, in relation to the European Union, the recast qualification directive does actually impose a slightly strange test in that it requires both the common characteristic and the perception as a group by society cumulatively to be present. But most states don't apply it in that way. So that's quite helpful. Now, what I also wanted to say in relation to that and to this point is that not just persons with disabilities can be members of a particular social group, but also their family members or carers can be associated with a person with disabilities, actually be persecuted because they are the carer of a person with disabilities. And also what is interesting is that persons with albinism also qualify as persons with disabilities, and the CRPD committee has clarified that in a case against Tanzania, that persons with albinism are persons with disabilities, both because they lack melanin in their skin and they normally have visual impairments as well. Right, so this is the first aspect of the refugee definition, and it is in a way the most basic one. It's actually really, as I found in my study, the easiest one to satisfy. Probably the most tricky and interesting aspect of the refugee definition is the question of persecution or serious harm. Because, like I said before, of course, if you're just going to go around a country and shoot all persons with disabilities or lock them up and torture them, they will qualify for refugee status. But that is not the problem of persons with disabilities in most countries in the world. The problem is very often one, as I mentioned before, of forced institutionalization, forced medical treatment, no right to independent living, no right to education, no accessibility in society in general, and lack of access to medical treatment and rehabilitation. And I've listed some of the CRPD rights here, and I've listed those that may be less familiar because they are disability-specific human rights. So the right to education is a right to inclusive education in the CRPD, a right to education wherever possible with non-disabled peers, not separately with disabled children. The right to accessibility is one that's derived from various other human rights, but basically means accessibility both of physically of buildings, of places, but also of information, of news, of anything. So that's another interesting right, also of work and so on. And independent living and being included in the community, as well as together, Article 19 coupled with Article 14, the right to liberty, are core aspects of the CRPD. And really the goal of the CRPD is to achieve as far as possible that persons with disabilities can live in the community, be supported, but not be segregated. And yeah. And you see here a picture of a person with disabilities, psychosocial disabilities, chained to a wooden bed in Ghana. It's from a Human Rights Watch, current Human Rights Watch report on persons with disabilities. And unfortunately, during my research, I saw plenty of pictures like this. It's not just one country where this happens. It happens in many countries, and it's actually quite disturbing how many people with disabilities in how many countries still live in wooden cages or caged beds, even in some European countries, actually. And of course, freedom from torture also includes the freedom from medical experiments. That's also a very specific, disability-specific formulation of the right. But what I also want to stress here is that several UN Special Rapporteurs on Tortures have articulated themselves on the situation of persons with disabilities early on and have emphasized that forced institutionalization may amount to torture or ill treatment as use of force that's beyond what is strictly necessary. And I'm saying this because sometimes in the case law, I have observed that courts would say, well, yeah, and then they were locked up. Well, they didn't know how else to deal with that situation. And I mean, that may well be the case, but that's not the question for the Refugee Convention. And the question for the Refugee Convention is there serious harm for reasons of disability? And if the person will be subject to institutionalization and treatment against their will, it is serious harm. I've also here referred to a European Court of Human Rights case in relation to forced medical treatment and institutionalization, where it was found to be an Article 8 violation and in certain circumstances an Article 3 violation. So at the time, at least, slightly less progressive, but I'm not sure the Article 3 violation would still be in question today, given the change in international standards since then. Also here, another former UN Special Rapporteur on Torture, Manfred Novak, who set this out a little bit in more detail, how there are very often poor conditions in such institutions and severe forms of restraint and seclusion, that children and adults will be tied to their beds for prolonged periods, really for days on end sometimes, with chains and handcuffs. Cages are used, net beds. Net beds are another way of cage beds. They just put nets all around the bed rather than bars. And over medication in order to calm them down. So forced medication as a way of calming them down. And then he sets out what actual physical harm results from that sort of treatment, and that it again may amount to torture or treatment. And I think the point is that I think that there is still in refugee law and in asylum courts a lack of recognition of the seriousness of this institutionalization that happens in many countries. And I've read several cases where this in fact was described as far less harmful than it actually is. So that's certainly one of the core aspects, but there are other aspects of human rights violations which may well amount to serious harm depending on the circumstances. There is an issue in relation to medical treatment, and I don't want to overemphasize it because it feels a bit like going back to the medical model, where all persons with disabilities were about was the need for medical treatment. And of course, we probably all know that in the asylum context, there is some quite restrictive human rights case law in relation to medical treatment and persons requiring medical treatment, where the European Court of Human Rights and also the Human Rights Committee are quite hesitant to say that it amounts to ill treatment if there is a lack of medical treatment. But of course, there are disability-specific aspects to this question. And one is the fact that persons with disabilities die 15 to 20 years sooner than the general population due to neglect in the general healthcare system. And there is also, and that is something that needs to be always examined in relation to each country and on the basis of country evidence, there is discriminatory denial of access to medical treatment. And one just very well-known example of that is persons with HIV. They often and still in many states get turned away from hospitals, from doctors, and get denied access to medical services, or get really poor quality. Sometimes, they have to consent to sterilization. Sometimes also it is because of prevailing prejudices that they are contagious and dangerous. And I've seen in the case law as well how some lower courts actually thought that was acceptable, the justification to turn away HIV persons in medical institutions because they are thought to be contagious, and then higher courts thankfully correcting that and saying, well, no, that is not an acceptable justification today. Yes, our states were like that many decades ago when nothing was known about the virus, but today that is just discrimination and nothing else. So there is a question mark over this, and if there is a discriminatory denial of access to medical treatment, it is certainly my view that that will amount to serious harm if, for the person concerned, the lack of medical treatment will have serious consequences. The final point in relation to serious harm that I would like to look at is the question of education, because unfortunately 98% of children with disabilities in developing countries do not have access to education. So it is an incredibly widespread problem, and it's something that remains to this day a huge issue. And what it does is, and there's actually a really good report by the Council of Europe, the former Council of Europe Commissioner for Human Rights, Niels Musnieks, on school segregation and the effects that has on children, because if they are not allowed into school, they won't have access to work very often later on, because they've just been excluded from society from the start, and they've just had an existence at home, not leaving the house in many cases from the beginning. So it's something that affects their entire lives. And in his paper, Niels Musnieks also says that there are a lot of economic arguments why it would be in the interest of the state to actually include persons with disabilities in the school system. I'm not going to read it all out here. And I have just cited one case from in relation to the European Social Charter, something we don't have in Switzerland, unfortunately, but we signed the earlier one, but we haven't ratified it, and we didn't sign or ratify the subsequent. So we don't have the European Social Charter, but other European states do, of course. And it's the sort of the economic, social and cultural rights sibling of the European Convention on Human Rights. And there was a case in relation to segregation, school segregation of autistic children in France, and it was considered a violation. And of course, I mean, segregation is one problem. When we look at asylum cases, it is actual denial of education altogether, not just segregation. So I want to move on to the last point in relation to the refugee definition. And it is another one of the points that to me are core for a disability-specific refugee definition. It concerns the failure of state protection. And in fact, something that often goes unnoticed or underanalyzed is the fact that a lot of the perpetrators of what the forms of harm I just looked at are state actors. So medical staff, school staff in state institutions are state actors. And again, the UN Special Rapporteur Manfred Nobeck emphasized that in his report, that it's actually, we're looking here not at private actors, we're looking at state actors who are causing the harm. So that's one aspect which in the case law is often not recognized in relation to refugees with disabilities. And the second point is that there is a particular problem concerning, as I mentioned before, domestic violence, violence at the hands of family members or carers. Yes, unfortunately, that is widespread in many countries. Families and carers just don't know how to deal with a person with disabilities. And there is a specific article, Article 16, concerning abuse and exploitation also at home. And the problem there is in refugee law that what also often goes or doesn't get analysed sufficiently is in those situations the actual accessibility of state protection for persons with disabilities, because they may be physically impaired, they may be mentally impaired and not able to actually turn to anyone for help. So that the whole question of whether the state is able to protect the person takes on a different form, because actually there is just no, unless you have very proactive guarantees, there is no effective state protection. So time is slowly running, and I would like to just highlight a few. So after this perhaps a less optimistic analysis, I want to highlight a few developments at the international level which do leave me hopeful. There isn't much yet, but there is a little bit. There is a few decisions of the CRPD committee in relation to asylum cases. One is the case of OOJ against Sweden, OOJ and others. It was a Nigerian family with a child with autism. And they had claimed that the return of the child to Nigeria would violate the child's right to health, to habilitation, to an adequate standard of living, to freedom from torture, new and degrading treatment, right to education. And they said, well, there was a big factual debate about how many hospitals in Nigeria actually were able to look after children with autism. But there were no preschool arrangements and virtually no hospitals or medical centres that could provide medical treatment for autistic children. And what happened in the case is actually the case became inadmissible because the Swedish authorities could no longer remove them according to domestic law. So actually the refoulement risk was gone in that case, and therefore there was no longer a question of a refoulement violation. But the CRPD committee went out of its way to stress in that case that such cases, asylum cases, would fall within the scope of the CRPD and that they are interested in examining them. And indeed, there has now come a case where they've decided the first asylum case concerning a woman suffering from depression and psychotic features, who was supposed to be removed to Iraq, and she would not have had access to medical treatment. She would have most likely ended up on the streets in quite dire and desperate circumstances. And the committee found a violation of the prohibition of torture and cruel, inhuman, and degrading treatment. So that is the first indication that actually sooner or later asylum states will have to take the CRPD and the human rights of persons with disabilities into account in asylum decision making when these decisions come. And of course, there is another forum which is also relevant. And in fact, we don't have the CRPD committee. We don't have access to it in Switzerland. We haven't ratified the optional protocol. But what we do have, of course, is the Committee on the Rights of the Child. And there has been a decision which, unfortunately, again, the case was discontinued. But it's still interesting to see that there's already been the first case concerning a child that was diagnosed with pervasive developmental disorder requiring specialized treatment, medical treatment, and schooling. And they claimed various violations, including right to health and education and prohibition of discrimination, etc. And Switzerland granted the child, and I assume the family, a residence permit, and then the case was discontinued. But yeah, also from the Committee on the Rights of the Child, they do have a general comment specifically on children with disabilities, and it is to be expected that there will be decisions in relation to refugee children with disabilities coming from their end as well. And I just include the sort of case law of the European Court of Human Rights and the Human Rights Committee in relation to medical treatment. These are sort of the only cases concerning persons with disabilities. And there's another one, of course, SHH against UK, but it doesn't go any further than this, unfortunately. And it remains the case at the level of the European Court of Human Rights and the Human Rights Committee that it's only very rarely that these cases will be considered to constitute a violation. But I think when we look to the UN committees, there is actually good reason to hope that asylum cases of persons with disabilities will soon get a more disability-specific consideration. And so on that note, I'd like to end and leave time for questions, and thank you very much for your attention.
Thank you very much for your presentation, and also for really respecting the time requirements so that we have some time for questions. I've received many questions on many different canals, on different sorts of new technologies. So I'll try to address some of them, and hopefully no one will be too frustrated. Perhaps one question, you've talked about the typical refugee. We've actually started the evening with talking about the typical refugee political persecution, and you've shown how disability-specific interpretations do not necessarily fall within that image of the refugee that we might have. But you've still given some examples that are really tied to political or let's say at least civil rights. So for example, that things that can be interpreted as torture that are really are not so much a stretch of the imagination. But then there's also the question of social rights and socioeconomic rights, and you've addressed it. You've talked about school, health, but perhaps can you say a little bit more on the question of socioeconomic rights, and to what extent a lack of protection of socioeconomic rights in the country of origin can really be a reason to gain refugee status in Switzerland or other European countries. So really the question of socioeconomic rights.
Yes, sure. I mean, I certainly can say, generally speaking, socioeconomic rights are something that rarely leads to a recognition of refugee status in Switzerland. It's not the same everywhere internationally, but I mean, yeah, I think in Switzerland, I mean, you'd have to show I don't even know how it's called in English, an unerträglicher psychischer Druck,
supportable psychological pressure.
It's not but basically an unbearable pressure, psychological pressure. But I mean, in the case law, that's very, very, very rarely recognized in general, and certainly even more rarely when it comes to socioeconomic rights. So I think in Switzerland, I mean, we can be happy if we get any recognition of persons with disabilities as refugees, full stop, not with socioeconomic rights. But in terms of generally speaking in international law, yeah, there are other rights that are very relevant. I mean, the right to work, the right to access to work. There are cases on that internationally that I've examined. Generally speaking, many of them have failed at the moment, and I think the way it is with socioeconomic rights and international refugee law, generally speaking, it does require, of course, a discriminatory element, although I think actually that is often met. I mean, there is one case, one really progressive good case from New Zealand concerning an albino from Egypt, where he was discriminated in his employment and in his tertiary education. So not like primary, but like with a university certificate. And he's a good example of what could happen. So he was discriminated in his university education. I think he did not get one of the certificates. He worked on the basis of a government scheme trying to provide affirmative action for persons with albinism. He actually got a government job, but was dismissed from that, and then tried to find employment in the private sector, couldn't because he was discriminated as an albino, and then opened a shop, so tried self-employment. And again, no one went to his shop because he was a person with albinism. And effectively, he ended up just being at home all the time. And he wasn't seriously attacked, but he was discriminated against and just sort of attacked verbally a lot, subject to verbal abuse on the streets, and effectively started just staying at home all day, not going out because he couldn't bear the abuse anymore. And that the New Zealand court said, the tribunal said, amounted to persecution. So that is a very progressive recognition of socioeconomic rights. And they did use, I mean, when they do recognize that, often they use actually, which is interesting, and not strictly speaking what the Refugee Convention says, but it's interesting, they used the situation that the person now has in that country. So they looked at the way he was living in New Zealand, how he had a normal life, he had a relationship, he even had a girlfriend, he had friends, he had a job, he did all these things, and the difference between that and the life he had before. So yeah, there are some examples, but it's still rare that socioeconomic right violations get recognized.
Okay, so you've spoken about albinism, which is actually really fitting since there have been several questions on albinism. One is, so if you could perhaps say a little bit more on how albinism is a disability, that perhaps with link to the environmental definition in the CRPD, and the question of prejudice or stigmatization. So there was some question on whether you could shed just some light on why albinism, except for, is considered to be a disability, and how that fits within the definition.
Yeah, I mean, like I said, it's actually the CRPD committee that has recognized that in two cases, I think X against Tanzania and Y against Tanzania, concerning, and I think at least one of them was concerning a person with albinism whose limbs have been cut off, because it is thought that these body parts of persons, in certain regions it is thought that these body parts of persons with albinism carry magical powers. So they have an incredible value in the black market. It's terrible. And they really get hunted down. And what happened in that case, but it wasn't investigated by the Tanzanian police. That's what the case was about. And in that case, the committee said that albinism qualifies as a disability. And in fact, they followed in the footsteps already of statements of the special rapporteur on the rights of persons with albinism and so on. And I mean, what they all say is, I mean, you have a lack of melanin in the skin, but I think, I mean, it does perhaps lead to some impairment in terms of the full enjoyment of the quality of life and in terms of sun, but I don't know. I mean, what they normally rely on is the fact that there's a visual impairment as well. And then they say, so coupled, the two things coupled amount to disability. But I mean, I don't think the reasoning is very detailed and very, and I think it just goes to show that the CRPD was not meant to go into legalistic details about what is a disability, I think.
So just the stigmatization would not be enough to constitute a disability?
Well, it's not what they said, no. Yeah, no. It's an interesting question, though. It's an interesting way of thinking of it. But no, it's not the way it's been analyzed so far. Yeah.
Okay. A follow-up question on that has been to what extent autism could be recognized also as being part of a specific social group. I don't know if you have any case law.
Yes, I mean, I think it's clearly. I mean, clearly disability and clearly it depends, of course, on the country in which test they apply. But I mean, it obviously is an innate, unchangeable characteristic. So it also meets the definition of a particular social group. And I mean, like I said, I mean, there was the case of the child with autism that went to the CRPD committee. And I mean, I think it was undisputed that that was a disability. Yeah. I mean, I think there are interesting questions in terms of when you aren't sure yet. I have a case like that now where you have a child and there is a possibility of whether they are autistic or not, or might be on the spectrum, and where does it start? But I would probably say the obligations start quite soon, as soon as that there is a suspicion that there could be autism.
Yeah, okay. So we've been talking before about the term unbearable psychological pressure, or that's at least how we try to translate it. And there's actually been a question on the chat concerning that. Someone who described a rather specific situation on a person that seems to be in Switzerland right now and has fled from Afghanistan, where he was forced not to use sign language and forced to oralize prayers, and threatened that his hands will be cut off if he was going to use sign language. So I think the question was whether you have heard of something similar or can relate that in one way or another to either a case that you've analyzed or that you've been involved with, or
No, I haven't. But it sounds like a really disability-specific case. I mean, goodness, no, I've never heard of that. I've heard of a lot of different things, but not of the fact that they sort of say you can't use sign language and we're going to cut off your hands if you do. Not that I would say that because I haven't heard it, it doesn't happen at all. It's quite possible. I don't think I've heard much about Afghan persons with disabilities, so it's very possible that that's the case. I'm not an expert on that question. I've never looked into that. I've not heard it, but it sounds like a very, very, very disability specific situation of persecution.
Yeah, it certainly does. Yeah, for sure. Another question, actually, several questions have been related to the intersection between different memberships of different social groups. So either between gender and disability, or gender and being an LGBTI person. But perhaps I think there have been several questions on gender and disability. So I don't know if you have any thoughts on that particular interrelationship, or also what could be the specific problems there, or how to address them best?
Yes, I mean, there is a lot of reports and also some standards in relation to women and girls with disabilities. And they are, I think, I haven't looked up the statistics now, but I mean, I think the statistics are horrific. I mean, they are so much more likely to be subject to sexual abuse. It really is, they're incredibly vulnerable in many states and in many situations. It's a huge problem. There's a CEDAW, I think there's a CEDAW general recommendation on that, on women with disabilities, which specifically addresses that. And I think the CRC also addresses it in its general comment on children with disabilities in relation to girls with disabilities. But it is both inside institutions that they will be more likely to be subject to rape and sexual abuse, and within the family and society in general. Yes, it's a huge problem.
Okay, yeah. Thank you for that. Perhaps you've talked about the child specific interpretation of refugee status several times, and also you mentioned that there is a guideline by the UNHCR on child specific interpretation of the refugee status. What do you think could be taken from that approach and applied when we suggest a disability specific approach?
Well, I think that's thin ice, because everything in the Convention on the Rights of Persons with Disabilities is about the fact that they are autonomous and are really supposed to be treated as individuals with full equal rights. And while children have full equal rights, they are not supposed to be treated like adults. And I mean, of course, persons with cognitive impairments and so on will require support, and there are specific articles in the CRPD on supported decision-making, and not substituted, but supported decision-making. That's a big shift. So I think in terms of, it is a it is true that there are parallels between certain situations with children and certain situations with persons with disabilities, but I think it would probably be a big insult to say, yeah, it's like children. But I mean, it certainly is the case that there are certain aspects of the refugee definition, like the subjective element of the well-founded fear, which have been relaxed in the context of children, and that can be taken as a precedent for saying, well, of course, the same needs to happen with persons with disabilities who may not be in a position to express subjectively the fear. But yeah, I think it's a tricky one to give a good answer on that one.
Yes. And I actually I didn't meant it in a stereotyping or stigmatizing a manner. I more thought about the question of being fully recognized as subjects of rights and not being treated as objects of rights, and being really in a sort of emancipating way. But I've also been thinking about the question of education that you've mentioned before. So the fact that the denial of education could be one reason to grant refugee status. Has that been the case in relation to children?
I mean, yes, with children with disabilities, for sure. There have been cases in Canada and also, I think, in the United States in relation to the denial of education and recognition of refugee status on that basis. Yeah, and that, I mean, for children with disabilities. So yes, there is that.
Okay.
I'm not sure there's any case in Switzerland though.
Okay.
Not children with disabilities, but children in general.
Yeah. So talking about Switzerland, there's one very specific question that I think we can take, and then we would go to one perhaps more general one, and then slowly close off already the evening. The very specific question was, what are your thoughts on the case Goul versus Switzerland? And the question of lack of recognition of disability-related issues and discrimination. Do you have any thoughts on that case? Or yeah, that was.
Hang on, which case?
It's Goul versus Switzerland.
Oh, Goul. Yeah.
Yeah, I tried to anglicize it and it didn't work.
Yeah. Ah, God. God, I haven't looked at Goul in a long time. I have to admit that. God, hang on. What was Goul against Switzerland?
It doesn't matter. It was more if you had any really.
No, I haven't. I'm sorry. It's a long time since I looked at that case for the last.
I actually have to say we know the person who asked the question, so we can get back to her later. She also asked another question. Perhaps we could close off with that question. You've mentioned that there are no specific UNHCR guidelines for now on disability. So I think what everyone here would like to know is, if you had to write them, what would you put in there? And perhaps also if you could give one or two examples of good practices of national court rulings, for example, that you would like to be inspired by.
Yeah, I mean, what I would put in them is of course, as is normally done with them, guarantees in relation to each individual element of the refugee definition, and procedural guarantees as well. In relation, but I mean, my main focus was the individual elements of the refugee definition. I mean, I think I've already hinted at some of what I would put in there. I'm trying to think now. I mean, there are, like I said, there are some really good practice cases from different countries, from different jurisdictions. New Zealand, the case I mentioned, the analysis on albino rights and on socioeconomic rights in the context of the person with albinism, that was a very exemplary analysis. The Canadian cases there are several. I mean, there are also cases, for instance, on the fact that in Canada, on the fact that a person with disabilities in a war situation will be more severely affected. A person with that was a person with physical impairments, but it could also be with mental impairments, will be more severely affected by war than the rest of the population, and therefore they got refugee status. I mean, there are various different examples, but I think generally speaking, what I would do is, go through each of the elements and cite human rights standards and case law, existing case law in relation to a disability-specific definition. But I'm not sure. I think I would have to go. I mean, I would like to do a draft, but I think to just you to have to go through each of the elements and the different aspects. But then it's and cite. I'm trying to think what other cases. I mean, there's many cases, but not that many. Then again, on persons with disabilities, I think I've mentioned a lot of good practice decisions already in the lecture and now with the questions. Trying to think if there are any obvious other ones that I haven't mentioned in terms of situations of persecution also. I can't think of any right now, but there would be more, I'm sure.
In any case, any person who will write these guidelines will have to read very closely your book, which really is very, very interesting, which I can say because I've read part of it. So perhaps if anyone is interested, we're happy to send out the link again. And I think with that we will close off. Thank you again very much for having shared your thoughts and your knowledge with us, for also having taken the time to answer so many of the questions. And thank you to all the participants who have been here tonight, for following, especially for following until the end, for asking questions, and for being with us tonight. And we hope that we'll be able to continue the discussion in other forms, trying to make these questions visible in the future as well.
Thank you very much. Thank you.